In this video, we're going to talk about the seminal Supreme Court case of Cavendish and Makdessi, ParkingEye and Beavis, which were two separate cases that were heard under the same appeal. In this case, the Supreme Court had radically revolutionized the law as regards to contractual penalties. In the case of Cavendish and Makdessi, Makdessi and Cavendish had entered into an agreement whereby Makdessi would sell Cavendish his shares in exchange for some termly payments to be paid in installments. Within the contract, there was a non-compete provision which prohibited Makdessi from carrying out any business activity which would be seen as competition with Cavendish. Furthermore, the purchase agreement between them also contained two provisions relating to what happens if Makdessi had breached this non-compete provision. In particular, Clause 5.1 states, and I'm paraphrasing here, if Makdessi breaches the non-compete provision, then Makdessi shall not be entitled to receive further payments from Cavendish in the future. The question for the court to determine is whether or not Clause 5.1 is a penalty. But not just that, they also had to decide what to do with Clause 5.6, which states that where Makdessi is in breach, Cavendish shall have an option to purchase any of Makdessi's remaining shares. And if Cavendish does exercise that option to buy the shares, Cavendish shall pay Makdessi an amount equal to the value of the company multiplied by the percentage which represents the proportion of any shares that Makdessi holds. Now, for our purposes, it should only be noted that this value that Cavendish can pay for in exchange for the shares is significantly reduced in Cavendish's favor, and therefore to Makdessi's detriment. So the court also has to ask whether Clause 5.6 is a penalty as well. In the second case of ParkingEye and Beavis, Mr. Beavis had drove into a car park built by ParkingEye. There were notices stating that parking was only limited to 2 hours. If someone had overstayed, then they would be liable to a parking charge of £85. Mr. Beavis did overstay, so to avoid paying the fine, he had argued that it was an unenforceable penalty. Turning to the background of this appeal, it is a basic principle of contract law that contractual parties can agree remedies between them. However, this power is not unfettered. If a contractual agreed remedy is a liquidated damages clause, then this would be enforceable in the court. However, if the court deems it to be a penalty clause, then that would not be enforceable. So how do we determine if a clause is a liquidated damages clause or a penalty clause? Well, prior to the 2015 case, this area was governed by the test in Dunlop. The Dunlop approach was characterized by the following. A clause would be a penalty if the sum stipulated was extravagant and unconscionable. Also, it would only be a penalty if the clause was activated only in the case of a mere non-payment of money. Moreover, if the price was payable in the event of various contingencies that spanned across a wide spectrum of severity, then that would likely also be considered to be unconscionable and therefore a penalty. And lastly, it must be noted that under the Dunlop approach, a clause would not be a penalty simply because that one cannot easily put a number or a figure to the loss that one party might suffer if the other party breached the contract. The Supreme Court took this opportunity to clarify, or rather reinterpret, the existing law of penalties. There, they departed from the old Dunlop approach and established a new test. Lord Neuberger and Lord Sumption wrote a joint judgment. There, they stated that the true test is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. Here we may see that there are three elements to their approach. Firstly, for a clause to come under the penalties doctrine, it must be a secondary obligation. If a clause is, however, a primary obligation, then the story ends there. Then one cannot use the penalties doctrine to try and argue that that clause is unenforceable. The second element is disproportionality, and the third element is whether the clause actually protects a legitimate interest of the innocent party. Now, this test was elaborated in Lord Mance's judgment, who wrote something on the same lines. He stated that what is necessary is to consider first whether any, and if so what, legitimate business interest is served and protected by the clause, and secondly, whether, assuming such an interest to exist, the provision made for this interest is nevertheless extravagant, exorbitant, or unconscionable. So this rings the same bells as Lord Sumption and Lord Neuberger's disproportionality requirement. Their lordships then honed in deeper as to the meaning of all these different elements of the penalties doctrine. Starting first with the requirement that the clause must contain a secondary obligation, Lords Neuberger and Sumption held where a contract contains an obligation on one party to perform an act, and also provides that if he does not perform it, he will have to pay the other party some money, the obligation to pay the specified sum is considered a secondary obligation, which may be capable of being a penalty. However, if the contract does not impose an obligation to perform, but simply provides that if one party does not do something, he must pay the other party some money, then this obligation to pay is only a conditional primary obligation and cannot be a penalty. To illustrate this, let's look at this example. In the first example, the promise had been worded as follows: "You must clean your room," followed by another term stating that if you don't, you will have to pay me 5 quid. This, according to Lord Neuberger and Lord Sumption, would be considered a secondary obligation, and therefore may be a penalty under the penalties doctrine. However, let's look at the second example, where the promise is worded, "If you don't clean your room, you have to pay me £5. Here, there is only one obligation, and therefore it is a primary obligation, or at the very least a conditional primary obligation, and therefore the penalties doctrine has no application here. As these examples illustrate, there is a danger of clever drafting, as Lord Hodge recognizes. He states that where it is clear that the parties have through clever drafting circumvented the penalties rule, and that the substance of the contractual arrangement is the imposition of punishment for breach of contract, the concept of a disguised penalty may enable a court to intervene nonetheless. So here the court emphasizes that they are looking at substance and not form. Turning next to the legitimate interest requirement, Lords Neuberger and Sumption held that the innocent party can have no proper interest in simply punishing the defaulter. His interest is in performance or in some alternative to performance, but compensation is not necessarily the only legitimate interest that the innocent party may have in the performance of the primary obligations. So we can see here that mere punishment cannot in itself be considered a legitimate interest. Moreover, the legitimate interest requirement is broad enough to encompass not just compensation, but perhaps other business needs. This was echoed by Lord Mance, who states that there may be interests beyond the compensatory which justify the imposition on a party in breach of an additional financial burden. For instance, the case law has suggested the maintenance of a system of trade, payment of costs which a party was prepared to forego if a settlement was honored, and the revision of financial terms to match circumstances disclosed or brought about by a breach may be considered legitimate interests. Turning then to the disproportionality requirement, Lord Hodson states that in judging what is disproportionate, extravagant, exorbitant, or unconscionable, the extent to which the parties were negotiating at arm's length on the basis of legal advice and had every opportunity to appreciate what they were agreeing must at least be a relevant factor. Lord Neuberger and Lord Sumption states, however, that the strong initial presumption must be that the parties themselves are the best judges of what is legitimate in a provision that deals with the consequences of a breach of contract. Last but not least, their lordships made some comments about the types of detriment that may be imposed by a clause, such that it would fall under the penalties doctrine. Their lordships held that it's not only clauses which impose upon another party to pay money that would fall within the ambit of the penalties doctrine. Lord Sumption and Lord Neuberger held that an obligation to transfer assets for nothing or perhaps at an undervalue can constitute a penalty. They also stated that a term may in some circumstances be a penalty if it disentitles the contract breaker from receiving a sum of money which would otherwise legally have been due to him. Having laid down the law, their lordships then went on to say how the new test applies to the two clauses in the Cavendish and Makdessi case and the parking charges in the ParkingEye and Beavis case. Starting first with Cavendish and Makdessi, and specifically Clause 5.1, which, as you remember, is a clause which states that one party may withhold the entitlement to receive money from the other party if the non-compete provision was breached. The Supreme Court was divided on this issue, with Lord Neuberger, Lord Sumption, and Lord Carnwath holding that Clause 5.1 contains a primary and not secondary obligation, as it is a substantive price adjustment clause contingent upon a certain event. However, Lords Hodge, Clark, and Tolson stated that they would prefer to have kept an open mind, and the rest of their analysis progressed on the assumption that Clause 5.1 contained a secondary obligation. Given that it was a 3v3 situation, Lord Mance would be considered a tiebreaker. However, unfortunately, Lord Mance did not come to a definitive conclusion on this matter as well. However, as we will go on to recognize, this in fact did not materially affect the outcome of the case, and that is because, firstly, they unanimously held that Cavendish indeed had a legitimate interest in Makdessi respecting the non-compete clause which extended beyond compensation. That is, to ensure that the price paid for the shares accurately reflected the company's value. If Makdessi just went around and freely competed with Cavendish, then this would have significantly reduced the company's goodwill, and therefore, Clause 5.1 can be deemed to have furthered a legitimate interest of the parties. Finally, their lordships also held that the detriment that Clause 5.1 imposed upon Makdessi was indeed not disproportionate to respecting Cavendish's legitimate interest. Turning next to Clause 5.6, which, as you remember, is a clause which gives Cavendish an option to purchase the shares, Lords Neuberger, Sumption, and Carnwath again held that Clause 5.6 was not a secondary obligation, but a primary one. However, this time around, 4 of the 7 justices came to a definitive conclusion that Clause 5.6 was indeed a secondary obligation, and as such, Clause 5.6 was construed by the majority to be a secondary one and therefore comes under the penalties doctrine. Moving next to the legitimate interest requirement, they also held that Clause 5.6, like Clause 5.1, respected and furthered a legitimate interest of Cavendish. Indeed, the fact that Clause 5.6 was designed to influence Makdessi's conduct, that is, to deter him from breaching a non-compete provision, was itself not an obstacle. Finally, they also held that the Clause 5.6 was not disproportionate. In summary, their lordships held that both Clause 5.1 and Clause 5.6 were not penalties, and therefore these clauses are valid agreed remedies clauses. So going back to my comment about Clause 5.1, it wouldn't have made a material difference to the outcome of the case whether Clause 5.1 was considered a primary or secondary obligation, because if it was a primary obligation, it would not have come within the penalties doctrine, and so it would have been valid anyway. Similarly, if it contained a secondary obligation on the other hand, then because it protects a legitimate interest of Cavendish and is also not disproportionate, it would also have been valid anyway. Finally, we turn to the parking charges in the case of ParkingEye and Beavis. Here, their lordships held that it was quite obvious that the parking charges constituted a secondary obligation. So the question is, did it protect a legitimate interest? They held that it did, because ParkingEye had a legitimate business interest in managing the car park scheme properly, in part to honor the contracts that ParkingEye had with other third parties. Another legitimate interest that this clause protected was in generating an income stream from the charges which it used to meet its operating costs. The parking charge also was not disproportionate with these legitimate interests as their lordships held. In particular, their lordships considered that the charge was not excessive compared to the usual charges that local authorities would have exacted, as well as car park operators in public and private car parks respectively. So in summary, the court held that the parking charges was a secondary obligation which protects a legitimate interest of ParkingEye and was not disproportionate. It was therefore not a penalty and hence valid.